Welcome to Ground Rules, Employment Law over your coffee break. My name's Pam Howland, and I'm here today with Megan Egbert. Megan is an attorney who works here with us at Idaho Employment Lawyers, and she brings an extra informative perspective to the topic we're going to discuss today because she's also a legislator here in Idaho. She's a representative for District 17. So today we're talking about the One Big Beautiful Bill, which impacts employers to some extent, and the changes that will bring in 2026. I have to admit, this is something a little bit outside of my comfort zone because when I first saw the types of issues raised in that bill, it didn't occur to me the extent to which that bill was going to impact employers. So Megan has helped us understand more about the provisions of that bill because as a legislator, our Idaho legislator, just like probably legislators all over the country, they're trying to grapple with how they're going to implement that and the extent to which they're going to follow the provisions in it. So I'm going to turn it over to Megan to tee this off and tell us a little bit about, why does the Idaho legislature even have to consider that? And what types of issues are you as a legislator thinking about with that bill in terms of how the state's going to adopt it?
Yeah, so happy to be here. The One Big Beautiful Bill, or sometimes I'll just call it OB3 at this point for short, although it was signed into law on July 4th of this year, 2025, it has various dates for implementation. And one of the big things to note about it is that parts of it, and specifically several of the parts we're going to be talking about today, that could impact employers, alter tax code. And so those changes actually have to go through the states. The states do this every year anyway. They decide whether they want to conform with that tax code or if they want to do their own thing. And so this session, which starts on January 12th for Idaho, the legislature is going to look at recommendations from the Idaho Tax Commission, and they're going to decide what parts of tax code they want to conform with and what parts they don't. Typically, Idaho conforms pretty standardly with our tax code. We did last year, we did for the last few years. I think 2017 was the last time that we didn't conform with it. But it's definitely going to be a hot button topic this year because of the situation we're in with our budget right now, in a budget deficit. If we conformed with the entire OB3, there's estimates that it would add about 160 million to our budget deficit if we fully conformed with it. So to be continued to see in the next few months what Idaho will do. One of the things that is nice for employers, though, with the changes we're going to talk about today, is that they recently announced penalty relief to employers for this tax year. So when it comes January here in a few weeks, and if employers have not complied with certain parts of it, specifically the overtime and the tips components that we'll talk about, they're not going to be penalized for that.
Okay, great. Well, this is pretty exciting. I didn't even know that we were calling it OB3. Now we know the lingo. We know how to be cool when we're talking about it. And we're just super grateful that we have Megan on board because she can kind of help us understand this and give us the peek behind the curtain as to what is going to, possibly be discussed and implemented by our legislature. And again, so we don't normally think of this as being an employment law bill, but we're going to dig in. And I think that you'll see there are some issues that could impact many employers out there. So even though Megan just talked about the penalty relief, you should still be, taking some proactive action now to make sure you know what's coming with this, what type of paperwork's required, and what kind of messaging you need to give your workforce. So let's jump in and talk about one provision of OB3, which is the no tax on tips. So help us understand that a little bit, Megan. What is that?
Yeah, and I will say too, the IRS has said that if employers can comply with it already, they certainly should. They just won't be penalized, but it's gonna be a best practice because this is something that you're gonna have to sort out anyways. And I think the no tax on tips thing has been floated around so much that it's really popular with employees, this idea of it. And I think it would be really hard for Idaho to not conform to this part. So my suggestion is that if you are able to comply with it, that certainly you should at this point. This would be a new deduction for people who work in the industries that are customarily and regularly receiving tips. And the IRS has a list of what some of these different positions are, but it would allow them to deduct qualified tips that are paid through cash or charge from their income, from their taxable income, with an annual maximum deduction of $25,000 in tips. So the most important thing for employers here is that they would just have to start tracking this if they weren't already, and that they would need to, report it to the IRS or Social Security Administration and provide statements to the employee showing certain cash tips received and the occupation of the tip recipient so that they can demonstrate that they are in one of those occupations. And just kind of an interesting thing about this is that it wouldn't apply to anything that is, like, added to your bill that's required, and so, sometimes if you go out to eat and you have a certain amount of people with you, they will add a mandatory service charge or gratuity to that, and those would not be included. So maybe we will see less of those because employees are not going to want those as much as they would want just the voluntarily given cash or charge tips.
Yeah. And we pulled up the list of what occupations are covered on this right before we started recording. There's a lot of occupations on that list. Some of the ones, I think we all hear that and we think food and beverage, right? We think servers. It's a lot of different positions in food and beverage, like probably no surprise, bartenders, chefs, food prep, fast food workers, dishwashers, host staff, bakers. So probably nothing too crazy there. But as I was going down the list, I was like, okay, yeah, there are a lot of occupations that get tips that are impacted by this. So nails, for example, manicures, pedicures, uh, some other types of cosmetology type things, tour guides. Here we're in Idaho. We have a pretty robust tour industry. Tour guide, shuttle drivers, personal care and service personnel. So think home health care type aides, people who do massages, nannies, maids in housekeeping, concierge services, baggage handlers. The list is pretty long. So that might be worth checking out if you are wondering if people working for you would be covered by this because it's pretty broad and there are some occupations here that I wasn't really thinking about when I first saw this. So, Megan was talking about there is a maximum annual deduction on this. That might be worth a communication to your employees about making sure everybody's on board with how this is going to work, what types of maximums are at issue here, and what types of record keeping and paperwork need to be handled because it's something new and different, and right off the top of my head, I don't know exactly what that would look like, but if this is something impacting you, you should check this out for sure. So communication, maybe you might even have some kind of policy right now that might need updated. I know we've seen handbooks before for people in food service that maybe have specialized policies about wages, tips, and how
Mhm.
that's handled. So check out your policies and think about the administrative side of this and messaging. So, wage an hour, definitely something that we consider to be in our wheelhouse, to a certain extent. Not the tax. We're not tax attorneys, so I'm certainly not saying that. But let's talk a little bit about the no tax on overtime piece and think through what type of implications that might have for Idaho employers.
Yeah, so this is another new deduction, and this would probably impact a lot of employers who regularly have staff who are getting time and a half because they're working overtime. So this deduction would allow employees for that half part, that time and a half part that they're getting of when they've exceeded 40 hours a week to not have to pay taxes on that income. It has a annual deduction of $12,500 maximum, so a little bit of a smaller amount there. But essentially, employers should already be tracking how much overtime their staff are working. That's why, they would be paying them time and a half anyways for that. But one of the things that, Pam highlighted a little bit here that we see in the employment law world happen a lot, and that, we have some concern with this part is that employers will just try to reclassify staff as exempt to avoid having to track overtime, to not have to worry about it. And that is something that we would definitely avoid doing if you are considering whether your staff truly should be exempt or not. We would encourage, giving us a call, because there's some detailed decision making that goes into that.
Yeah, and that is something you've heard us talk about repeatedly this year is the importance of making sure that your employees are properly classified and that you've really given some thought and possibly even have some documentation showing why your exempt employees are exempt and what exemption they actually follow. And if you don't know the answer to that, thinking about an audit of some type, that would be a very good something to implement there for 2026 if you've never done that. Some employers are surprised to learn that you can't just call someone a salaried employee and then not pay them overtime. There are very definitive tests that go along with that. We have both a salary portion of that test and then a duties portion of that test. Um, it it's pretty rigid, really. So hopefully, you've actually done the analysis on that and you've got job descriptions and you've looked at those and you've actually made sure that the people who are exempt. But at any rate, maybe that's even more important than ever in light of this new law that's going into place that will have some new implications.
I think so, and I also think that this is going to incentivize employees even more to want to perform overtime. So that's something that employers need to be aware of. Also checking their policy on overtime for their non-exempt staff members. Who needs to be giving permission for that to occur? When is overtime approved per your policy? When is it not? Because now, in addition to that time and a half that they're going to be compensated for, they also are going to get the tax deduction for any of those hours worked. So that's just something to be aware of on the policy side of things too.
Yep. Yep, that's good stuff. And then again, like messaging, because this is one area that employees are probably hearing a little bit about on the news. But as you've just heard from Megan, there are some nuances to it. There are some guardrails on it. It doesn't just mean that every overtime hour for the entire year is going to have this applied to it. So making sure everybody's on the same page. To me, that annual deduction maximum of 12,500, that just doesn't seem like that high of a number. So I'm guessing that employers are going to need a tracking system. Do you have that in place so that when someone's hit the 12.5? Just making sure your record procedure is up to date, your classifications are good, and that your policies are updated and your employees know how this is going to work because it's
Mhm.
probably going to take a little bit to get it in place.
Yeah.
Okay, tell us about other changes under OB3.
Yeah, just some, small ones for large ones, but small things for employers to be aware of, I think, is that there's expanded uses for health savings accounts. So if that's something you offer for your employees, I would just check that out. It's really a benefit for employees. They're going to be able to use those health savings accounts in more ways than they were able to before, which is really something that you would probably want to share with them, especially as we talk about here in a minute, kind of some of all the other challenges facing employers right now around healthcare. This is one where you can say you offer a health savings account, you're going to be able to use it in more ways than you could before. The same with flexible spending accounts. This is something that's often used for dependent care expenses, where an employee can take advantage of that pre-tax account and not have to pay taxes on it. And they now can, there's a higher limit of what they can put into a flexible savings account. It increased from 5,000 to 7,500 per household. So that's another perk that if you utilize those, you can really just encourage staff to take advantage of. Same with paid family medical leave credit. So just so that we're not freaking anybody out, this is not a required thing that employers have to do, but there is a tax credit for employers who choose to pay staff for family medical leave, that they can take. And there's been a lot of uncertainty around from that credit in the last few years, and OB3 made it permanent. So it's just something that employers can now count on. If you offer paid medical leave for your employees, you just know that that tax credit is going to be there. And then I think the other things that we're just anticipating as trends, somewhat as a result of OB3 and somewhat just as a result of where we're at right now, looking forwards to 2026, is that employers are really feeling the crunch right now of increased health insurance costs. And, there was SHRM talked about a survey recently where employers said that this is their number one concern going into 2026. We just saw some massive increases to health insurance costs. And, there are predictions that in 2026, it's going to average an increase for employer paid health insurance of possibly up to 10% increase in what they're paying for these health insurance plans. And that is a lot for employers to be thinking about right now.
So when you were meeting with your work groups
Mhm.
and the trends, including the increased cost of health insurance, were being tossed around, what were some of the employment law impacts that you were hearing people concerned about
Yeah,
discussing?
I heard from a HR person in North Idaho recently who was talking about what a challenge this is, especially in North Idaho where there's, competition in Washington, where employees are being able to choose, that they could maybe drive 40 minutes extra and get better health insurance for a competitor in Washington and what a challenge that is. And this HR professional was talking about some of the things that they're thinking about in her own organization is preventative care for new reasons now, right? So fewer employees are probably going to be able to have insurance in 2026 for a multitude of reasons, whether it's that, employer plans are changing because of the increased costs, and or whether it's, some changes to Medicaid and the Medicaid expansion that some employees had been on. Um, and so they were looking at, what are the costs if our employees are losing some of this preventative care, and they were really concerned about an increase in potentially FMLA leave, right? If employees aren't taking care of their healthcare needs now, then they're going to turn into serious situations where they need extended leave, or are they going to see more accommodation requests because their employees aren't getting the health care that they need. So one thing that they know they were doing at this organization, which I thought was an interesting way to address it, is they decided to start giving their employees 4 hours of leave annually for preventative care reasons. So separate from their PTO, just 4 hours of leave that if they needed to go get blood work done or whatever their annual, checkup was, that they had some time to actually address those things before they turned into these situations that we see on the employment law side so frequently.
Yeah. So I guess one thought that was coming to my mind was maybe for employers to dig a little deeper and see what else is out there for other resources. For example, like maybe EAP programs, like ways your employees can get help, even if it's not necessarily covered in your regular insurance package. I'm not 100% sure what that looks like. Um, but it does seem like employees not getting the help and the medical resources, whether it's mental health or physical health, that is gonna lead to more claims and more problems. And while in Idaho, you might be thinking, well, so people take more FMLA leave, that's not an out-of-pocket cost for me. But the answer to that, I guess, or at least just one issue is, yeah, but you got people out of the workplace. Who's performing that job if your people are unable to work, and if they're gone not being productive and performing? So I can see a lot of ways that that's gonna trickle into the workplace. I would say more important than ever, and I would say this anyway, and you probably have heard me say this a million times, make sure you know your ADA policies, protocols, that you've got the updated policy. Same with Pregnant Workers Fairness Act, any of your accommodation statutes that require you to take action when people are having health conditions. Make sure you got that figured out too.
Yeah, definitely. I mean, and as we always say, right, like supervisor training to identify these things too, because I think the worst case scenario here would be when maybe a very simple accommodation early on in the process could prevent what then happens and ends up being, FMLA leave, a much longer extended period of time that somebody is out of your workplace, and it ultimately will be more expensive for you the longer it takes. So identify those early and address them.
What other trends or issues under OB3 that we haven't talked about are on your radar?
Yeah, so one of the things that's, also a little out of our wheelhouse, but just for employers to be thinking about, and I'm sure they are thinking about this anyway, is that there was a large budget increase in OB3 for ICE. And many people are suggesting that this could lead to an increase in ICE rates in the workplace. So I know that this is especially important for people who work in the food industry or manufacturing, food production, those type of agricultural industries. There's a lot of them who I think are thinking about this and whether that could impact their policies. And then one of the interesting things that didn't end up in OB3, but there was a lot of conversation around, was what they called the AI moratorium. And this would have put a 10-year moratorium to prevent states from enacting their own AI legislation. The idea was that so everybody could get on the same playing field basically when it came to AI and enforcement around it. What this means, though, for employers, and especially ones who work in multiple states, is it could get really interesting now that because that wasn't included in it, states are able to enact whatever AI policies they want. And so employers who operate in multiple states could be in a situation where there's very different policies around AI in one state than there is in another. And so California recently, just in October, promulgated some rules around AI that really impact employers. And we could see this from some other states too, like such as, they specify that it's unlawful for an employer to use an automated decision-making system or selection criteria that discriminates against an applicant or employee in an employment decisions. So, for example, if they're using an automatic system that is discriminating on the basis of gender or race or disability, they're not allowed to do that. And they might not even know that it's happening, right? That's one of the things that we see with AI a lot is that um, there's some employer liability sometimes, even when they might not be aware of what the system is doing.
So a couple points to that, and then I want to make a couple comments about the ICE
Yeah.
increased ICE budget. Uh, that anti-bias testing for AI, that is in the compliance world certainly something that we're thinking about because the legal authority that's trickling down on this, that where you have some type of AI algorithm that commits discrimination in hiring or discipline or something else, the anti-bias testing is definitely the one of the proposed fixes for that. In our world, the question becomes, what the heck is that? How do you do anti-bias testing? We had a episode several months ago where we were talking about that a little bit, and we put it out there like if you have implemented anti-bias testing and would love to share that with us, please let us know because even though that is the phrase with AI, I'm not 100% sure what that looks like and how you do that and what employers are doing and what type of success they're seeing with that. But that is definitely a phrase to watch out for, anti-bias testing. The other thing that occurred to me as Megan was talking about state AI laws, if you have employees in more than one state, like say you're here and you have employees working virtually in Washington, Oregon, Montana, and Utah, that would not be unheard of here. Anytime you have states implementing their own legislation, that's going to create some challenges for you, right? So it's better to be staying on top of what's going on in the states where you have employees working. That's a big deal. Back to the ICE raid concern and the increased budget for ICE. We're not immigration attorneys, but we would recommend you maybe get one if you have concerns about how that's impacting the culture in your workplace. If you're hearing that thinking, I have no idea what we would do if there was an ICE raid in our workplace. Now's the time to take action on that and to get an attorney lined up. Reach out to us if you need some referrals. We know the landscape of that locally here somewhat and get a plan in place. Just like with uh, DOL, Department of Labor, wage and hour audit in the workplace. That is something in our wheelhouse, and we've talked about that before. The whole really secret to having a good outcome on that is some preventative, proactive planning. Like what would we do if someone showed up at the door and started asking for records and employees? That is not something you want to be handling at the moment, flying by the seat of your pants. You want to have given that some thought. You want to know who to call, and you want to know what type of things you should be doing now to make sure you get a fair outcome that doesn't really negatively impact your business.
Absolutely. And I just add to the state AI policies. I was recently at a conference where they asked the audience how many people in the audience are using AI in their workplace. And maybe two-thirds of people raised their hand, and the speaker said, "Those of you who aren't raising your hand just don't know that it's being used in your workplace." And I thought that was so interesting of, like, the question really no longer is AI being used in your workplace? It's, are you aware that AI is being used in your workplace? And so I think that that's such a signal too for employers that it's really time to think about an AI policy. And this is something that, we talk about when we're doing handbooks for employers all the time. And we often hear from people like this doesn't pertain to us. Sometimes we push back a little bit and be like, I
Mhm.
actually think it might. I would rethink that one. And so, An AI policy can really help employers set the scope of what is acceptable and what's not in the workplace. So I would encourage that 2026, if you don't have one of those, you might want to reach out because I think it is time for almost every industry to start thinking about how AI should be used in their workplace.
Yep. So, as we wrap up here today, thinking about OB3 and what you can do to get ready for it, it just kind of strikes me like at the end of almost every podcast, there are a handful of things that if you're doing those, you're going to be pretty well set to handle almost anything and to avoid claims and lawsuits. But some of the things we've talked about today, uh, get your wage and hour house in order. That one might be the biggest one, right? Because we clearly have that the overtime issue and the tip tax issue. So get your wage and hour house in order. Do an audit if you haven't done it. Brush up your policies. And then your messaging, right? Make sure you got your protocol and your messaging to your workforce. On some of these other issues, now's as good a time as any to get some extra ADA training. Make sure if this is going to be a year where we see increased ADA issues, make sure somebody in-house knows how to handle those and you've got the right policies and protocols in place. I'll throw in there, same with Pregnant Workers Fairness Act. That's a newer law. Some employers don't even know it's out there. There's a big accommodation piece to that as well. Policies, think about your AI policy, get your job descriptions updated. All of those things will serve you well, even if these issues don't touch on your business. Those are just the best practices. And now, as we wrap up 2025, there's no better time than now to kind of get going on some of those things. If you're listening to this and if you're thinking, I don't really know those wage and hour issues, and I don't know the ADA issues, our Law for Leaders Desk Book Guide is perfect for that. It gives you in a simple, easy to read chapter the basics on the ADA, some wage and hour basic. It makes the perfect Christmas gift, did you know? And on top of that, it'll help you maneuver through all of these things as well. So that is it for today on Ground Rule. And as it turns out, this is our last podcast for 2025. So we will see you next year. Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.